Delhi and New Delhi. What's the big difference? See, whenever you read an article on international affairs, they always say Washington imposed new sanctions on Russia or Beijing granted another loan to an African country. Because the media uses the capital of a country as an embodiment, as a personification of a government. Because capital is the seat of the federal or central executive and also the legislature and also the Supreme Court, all the three essential organs of a state or of a government. Then you never see foreign newspapers using Delhi while referring to Indian government. They always say New Delhi. They always use New Delhi because Delhi is like a state with 11 districts, and one of these 11 districts is New Delhi. And this district called New Delhi is the capital of entire India. So a district is the capital of entire India. I'm repeating. Then it'll surprise you to know that no part of New Delhi district is directly under the control of Delhi government, the elected Delhi government. And neither are any districts in Delhi, despite Delhi having an assembly, a cabinet, a council of ministers headed by a chief minister. This is the reason why you always see Delhi government under Kejriwal and the center always locking horns on Delhi's administration to a point where it's very obnoxious. But both of them are justified in their own right over their claims over Delhi. But none of them can assert their claims absolutely. This is because of Delhi's very fascinating governance setup and how it's a blend of a both state and a union territory. So both the state government and the union government have overlapping claims at times. In this episode, you'll find out about very captivating administrative history of Delhi, its governance setup after 69th Amendment, and then the judgment of the Supreme Court when Delhi and Centre moved the Supreme Court to adjudicate on powers of Centre and Delhi government in Delhi, and a lot on the arguments made before the Supreme Court and Delhi High Court, because that's what this podcast is primarily about, the novel and clever legal arguments. It starts with the British rule, Of course, the British rule. So, the British ruled different regions when they were reigning India with different setups and different for a host of reasons. At the top was the Viceroy, who's also called the Governor General, and this Viceroy was the head of entire British India. He was only answerable to Secretary of State in Great Britain, and the office of Secretary of State was, of course, in London. Yeah, there's no one above Viceroy in India except for Secretary of State, who is again not in India. This Viceroy ruled presidency towns such as Calcutta, Bombay, and Madras through a governor and a council called Governor and Council. And this council received a few non-binding advices at times from an elected representatives, like the elected legislative assembly. And since their advice was non-binding, the legislative assembly is virtually impotent. Then the Viceroy controlled regions that were not presidencies through a single person called Chief Commissioners, and hence these regions were called Chief Commissioner provinces. And just with a single Chief Commissioner, because these areas were either very low in population or so important that it required Viceroy's direct supervision, because Chief Commissioners were directly appointed by the Viceroy. Then there were princely states, which were sui generis. They were a class apart because they were administered by native princes themselves. But these princely states were loyal to the British on issues of war and foreign policy decisions. In fact, the British even controlled the princely states' international affairs or affairs that affect British interests internationally. So, for all practical purposes, we can count princely states as being administered by British, but a certain level of sovereignty was reserved for the princes. So, after independence, all the princely states were integrated with India. Immediately after, changing the governing setup of different regions wasn't the top priority of the government because it had to deal with mass exodus and voting and drafting the constitution, and there was no harm in retaining the existing framework of governance for the time being. So until 1956, all the regions in India, all the states and union territories as we call them now, were administered exactly with the setup Britishers left it, but through elected leaders. That was the only difference. So The ones run by Governor General in Council and a legislative assembly, the toothless legislative assembly, were Bombay, Madras, Uttar Pradesh, and these were called Part A states. Former princely states like Hyderabad, Jammu and Kashmir, and Madhya Bharat, Mysore, Travancore, Cochin were called Part B states. Then Part C states were Chief Commissioners provinces, Ajmer, Coorg, Delhi, Bhopal. And Part D weirdly only had one state, Andaman and Nicobar, and it was directly administered by a lieutenant governor. Again, this categorization was just temporary. The real delineation was done on the report of States Reorganization Commission and with the enactment of States Reorganizations Act 1956, which was based on the report of the earlier previously mentioned commission. And this act delineated states on linguistic basis. And this act just created two classifications. This act reduced all the Part A, B, C, and D into two: states and union territories. That's it. And states were run by a chief minister and a cabinet with the governor as a head of state, and union territories directly by the prime minister and his council of ministers, with president as the head of the state or as the head of the union territory, and union territory or state in a general way. States were sovereign in all issues in list 2, mentioned in list 2 of the constitution, but union territories were entirely administered through a president delegate called an administrator. And this administrator has to be of an IAS cadre and has virtually no discretion. They have to directly report to and take orders from the president, who in turn takes orders or advice or binding advice from the council of ministers. Now, in states, a governor too is a delegate of a president, but belonging to an IAS cadre is not a prerequisite. And another very irrelevant but very interesting thing is that the adjective of governor is gubernatorial. Yeah, it's GOBERNATORIAL, not governorship as many people might assume. So yeah, do whatever you want with that information. You can just boast it in front of your friends. And Pondicherry, that's an interesting union territory, because Pondicherry, although it's a union territory, it has a few state-like features, because when it was officially annexed to India from France in 1962, one of the conditions of the merger was that Pondicherry citizens shall have some franchise rights. So they got an elected assembly through a parliamentary mandate and not a constitutional mandate. And this is as opposed to New Delhi, as you'll know further, that Delhi's legislature has a constitutional status. So broadly, this is a setup of India. Every region is either a union territory or a state, and union territories are governed directly by the center, with powers flowing from Article 239, and the states through a bunch of articles which you already know. So, a disclaimer here: I'll be referring to the union government or the federal government as the center for the sake of brevity. So, yeah. So with this federal structure, states and center have few exclusive powers, and neither states nor the center can interfere with others' powers. And this is a constitutional prohibition, and it's not just an informal bargain through a few treaties. And of course, there can be encroachments under exceptional circumstances like emergency and war and all. But that too just by the center on the state's powers and not otherwise. But broadly, India's is a federal structure. And whenever center tried to encroach, the Supreme Court came to the rescue of the states. And this federal structure is a win-win for both the center and the states in a way, because the states don't have to worry about foreign relations, army, currency, patents and everything, and generally issues of national importance. And the center doesn't have to bother about local administration and civic responsibilities and local law and order. So the setup was this simple and straightforward, just until when the parliament got bored and when it wanted to harass all the law students. So it changed the setup of Delhi. See, until 1911, Delhi wasn't even the capital of India. It was just a part of Punjab province. Of course, it had its own historical significance, but under the British, it was very much neglected. And to your surprise, Delhi was actually under the jurisdiction of Lahore High Court, and the one in Pakistan. And after partition, it was under Punjab and Haryana High Court. And Delhi didn't even have its own High Court until 1966. And this is also obvious that Delhi was much of a part of Punjab, from the famous Bridgebushan case, where the impugned organizer magazine was published in Delhi, and Bhushan was charged under East Punjab Public Safety Act 1949. There was no such thing as Delhi Act or anything. So Delhi was very much a part of Punjab. And it was only after Delhi became the capital of British India in 1911, after shifting of capital from West Bengal, was it given a special status as a chief commissioner's province, because it was declared the capital of entire British India. And after independence to Delhi, as I've mentioned earlier, remained a Part C state, because Nehru thought Delhi being a capital city, it holds prominent stature, and it requires to be run very, very efficiently, and it must be guarded with all the life. And Nehru thought it would be too burdensome for a local government to handle Delhi, especially when the stakes are always high in Delhi. So Delhi is directly administered by the center through again a lieutenant governor. And the center created virtually, and all of this was immediately after independence. The center created a virtually toothless assembly for Delhi, and it scrapped it in 1956. Remember, 1956 was the year when Indian territories were reorganized on linguistic basis into states and union territories. And this is when Delhi too was made a union territory. Despite heavy resistance, because Delhi was a rather big state, and making Delhi a union territory would mean that taking away franchise rights of literally all the citizens of Delhi. And Delhi citizens, of course, wanted their own franchise rights on par with citizens of other states. Now, there are sound reasons for retaining Delhi under the center's control, because Delhi is the capital of India, and the center has almost all of its offices and residences of all the ministers and senior government officials and foreign dignitaries and who's who in the government in New Delhi. And New Delhi is also face of India in international arena, and surrounding regions of New Delhi will have inevitable impact on New Delhi. So it has to be free from petty politics, and maintenance of law and order, upholding its dignity, and effective allocation of all of its resources, especially land, is of the highest importance for efficient functioning of New Delhi. And also, Delhi was not self-sustainable financially too. So it was not feasible to run Delhi without center's financial assistance. And if you see capitals across the globe, capital cities hold political and social predominance, and any delegation of powers to a sovereign body within the capital led to conflict, and it would produce embarrassing situations for the entire nation. And these were also the observations made by a few committees appointed for the purpose of assessing the status of Delhi among Indian states and union territories. And deriving reasoning from the reports of these committees, the center classified Delhi as a union territory with no elected body. And all of this was in 1956. And obviously Delhi citizens were not satisfied with this setup, so they made constant demands to make Delhi a full state, and they sustained their demands for a lot of time, and the government succumbed, and it formed the Balakrishna Committee to look into the reorganization of Delhi. And this committee was initially called R.S. Sarkaria Committee, but when Justice Sarkaria resigned, Balakrishnan became the new chairman, and hence Balakrishna Committee. This committee submitted its report in 1989, recommending that the erstwhile state of Delhi should be accorded special status as national capital territory among all the union territories, because all of this time since 1956, Delhi was a union territory. The committee noted that the most of the difficulties faced by the citizens of Delhi can be attributed to, they call it structural inadequacies and flaws of the existing setup. And the committee suggested that while the center should retain substantial control over the governance of national capital, the citizens of Delhi also need an accountable representative body to administer all the civic activities that impact their day-to-day lives. And the committee suggested the revival of a legislative assembly with restricted powers to deal with day-to-day matters. Basically, Delhi's legislative assembly is a little more than, if you live in a metro city, your own municipal corporation. And relying on the report relying on this report, in 1991, the Parliament passed the 69th Constitutional Amendment Act. And this act inserted Article 239AA and 239AB. And this act provided for a legislative assembly in Delhi, and to complement it, National Capital Region Delhi Government Act 1991 was also passed with provisions relating to Legislative Assembly and Council of Ministers. This Government of Delhi Act is basically its own little constitution. And this is a legislative history of Delhi, legislative and actual history of Delhi too. So now, what are the powers of this new assembly, and how is Delhi special? So with these changes, Delhi got an elected council of ministers and the power to legislate on entries in state list and also in concurrent list, with a big rider that Delhi Assembly can legislate on entries in list 2 and 3 if those lists have any items that are applicable to union territories. And I repeat, if they are only applicable to union territories. At the same time, Delhi government was constitutionally prohibited from meddling with issues of land, public order, police, and services. These are the 4 things. And these are for the obvious reasons. Again, land, because the central government needs land in Delhi, how much ever the capital city might be expanding, and they definitely need land. And public order and police are crucial for maintenance of public order. And basically, land, public order, and police are the most potent power nodes in a state. And without them, the assembly is basically relegated into a civic body, as I mentioned before, because it's left with what? Education, health, sale of electricity, gas, and all the similar elements. Not that these are useless for a person's well-being, but they're not given as much as value they deserve to, and they're not that powerful. And again, amidst all of this, there's a big catch. The parliament was given overriding powers on all the legislative entries. So if the parliament passes a law, this statute becomes a law of Delhi, and any law passed by Delhi Assembly stands revoked, even on education, health, gas, or similar domains. Even if Delhi Legislative Assembly passed a law, if Parliament passes a law on the same subject, all the provisions passed by Delhi Legislative Assembly would stand revoked. So, Delhi government's lawmaking mandate, Delhi legislature's lawmaking mandate subsists until centre steps in, just like the powers of a state over entries in concurrent list. And all of these issues that I mentioned before are drafted in Article 239AA. And Clause 4 of the same article provides for a Westminster cabinet system where CM and his ministers would quote-unquote aid and advise the Lieutenant Governor on issues the legislature is competent to enact. Now, with states in India, the phrase aid and advise the government meant that the governor shall be bound by such advice tendered by the chief minister and his ministers, because governor is merely a figurehead. So, what does this mean for Lieutenant Governor and Delhi Council of Ministers? This is a bone of contention, and with this uncertainty, there's a big catch here. The Constitution enables the Lieutenant Governor as a president's delegate to refer any decision, like literally any decision for the of the Delhi government for the consideration of the president, and then the decision of the president shall be final. Then Lieutenant Governor also has the power to take quote-unquote necessary action if he thinks it's necessary, even if the reference to the president is pending on that issue. So Lieutenant Governor's powers are much more wider than governors of states, because Lieutenant Governor has a lot of discretionary powers, unlike a governor. And here too, because Lieutenant Governor is not required to abide by the decision of the Council of Ministers. So to round up, Council of Ministers has the executive power over some issues in List 2 and 3, but the Lieutenant Governor can refer the matter to President at his own discretion, and if that's the case, President's call would be final. So, Council of Ministers and Delhi Legislative Assembly isn't entirely sovereign, because they're not the final authority. There's a superior authority over them. And then again, Clause 3 also gives the centre full control over police, land, and public order. And obviously, this includes their appointment appointments to all of the institutions that manage these bodies. And the constitutional jargon for appointments and anything that deals with government job is services, because it's state discharging its service to the citizenry through these officers, and that's why it's called the broad label as services. Then Article 239AB, the second added article through the Act, it says that if the president thinks fit, he or she can suspend partial or full operation of Article 239AA. So, unsurprisingly, with different parties at the center and state, and coupled with murky power borders between center and state, there is a possibility of Delhi government or the union government encroaching onto others' domains. And they did just that, and they approached the constitutional courts with their problems. And these problems were like, who's the competent authority to appoint a special prosecutor? And who's the appropriate government under the Commission of Inquiry Act 1952? And whether Delhi government is qualified to revise minimum rates of agricultural land, because land is land is a reserved entry for the center. And then who controls Delhi's electricity department, center or Delhi? Meanwhile, an FIR was booked by ACB against Mukesh Ambani's Reliance Industries, alleging corruption with central government employees. And Reliance too filed a writ for quashing of the FIR by the ACB of Delhi, contending that Delhi's ACB is not empowered to lodge an FIR and start investigation in offences under Prevention of Corruption Act 1988, especially the ones committed by the central government employees. And it is not material to the discussion, but FIR was filed against former UPA oil minister for colluding with Reliance to drive up oil prices. And then the arguments in Delhi High Court with us. And first, the issues were challenged through a writ petition before the Delhi High Court. And as usual, the arguments were carried out on all issues. But out of the blue, at the end of the arguments, literally, Delhi government filed a petition under Article 131 in the Supreme Court. And under 131, a dispute between center and states has to be adjudicated by the Supreme Court. And pending this suit in the Supreme Court, Delhi government unsurprisingly raised a jurisdictional objection in the High Court, claiming that this case involves interpreting constitutional federal relationship between center and Delhi, and that the High Court is obviously not empowered to adjudicate these issues. And so Delhi government basically argued that this dispute in reality is a federal dispute between Delhi and the center, and since all the federal disputes shall only be adjudicated by the Supreme Court, the Delhi High Court has no jurisdiction to pass any orders on these issues. At the same time, remember that all of this was at the fag end of the proceedings in Delhi High Court. And alternatively, Delhi High Court argued that even if we remove 131 out of the picture, now that a suit on the same subject is sub judice in the Supreme Court, all the proceedings by Delhi High Court must come to a standstill. And the center countered back. And the center accused Delhi government of abusing the process of the court for filing the 131 suit at the fag end of the proceedings. Then the center countered by pointing out that Delhi is still a union territory and not a state. And Delhi still is listed as a union territory in Schedule 1 of the Constitution. Then center argued a federal issue only involves dynamics between center and states. And Delhi is not a state at all. It's a union territory, and union territories are directly controlled by the center. So Delhi too is directly controlled by the center. So since the sovereignty of Delhi is in the hands of center, just the postulation of Delhi government filing a case against center is absurd, because it would be like one entity filing a case against itself. It's ridiculous. Countering this objection of jurisdiction, Delhi High Court maintained that belated objection is of no consequence because there is inherent want of jurisdiction for Delhi High Court, and this jurisdictional issue goes into the root of the matter. And if the High Court passes any orders on these issues, they would be void ab initio. And naturally the High Court rejected the proposition that 131 ousted the High Court's 226 jurisdiction, also because it was also sub judice in the Supreme Court. In the facts of the case especially, it's not a general principle. And the court cited many precedents and held that 131 enters the stage only in the context of constitutional relationship and also legal rights flowing from those relationships. Then the court noted that political wrangles or questions of existence or extent of a legal right doesn't attract 131. Then the High Court summarily explained that dispute in appointing a dispute in appointing authority of a special public prosecutor isn't a federal issue, and neither is investigation of corruption of central government employees by Delhi government. The court said these issues involve just determining the vagaries of government orders on constitutional principles and also under GNCTD Act, the Delhi's own constitution. And the court then went on to hear the case on merits and passed relevant orders. But the ratio is not relevant because a few of the ratios were overruled by the Supreme Court in the appeal. So instead, we'll just fully focus on Supreme Court's ratio on all issues because that's the law of the land. And the case reached the Supreme Court. And in Supreme Court, the Delhi government argued that with Article 239 AA and AB, Delhi is neither a state nor a union territory because Delhi's characteristics and powers are more like powers of states, which other union territories don't possess at all. So Delhi holds a hybrid position, Delhi government argued, because it has a constitutionally created legislative assembly in contrast to Pondicherry, where it has merely a statutorily created created legislative assembly that were created by the parliament. So these peculiarities make Delhi sui generis, a class apart, and not comparable to either states or union territories. And then Delhi government argued this position is also taken by a 9-judge bench in New Delhi Municipal Corporation versus State of Punjab. So the court shall not view Delhi as just a union territory under the direct control of the parliament. Then the Delhi government submitted that since federalism forms a part of the basic structure, the courts must interpret a provision to further augment, to further consolidate these basic features. And for that, in case of any ambiguity, the court has to take a liberal approach for interpretation, and especially for the issues at hand. And the court shall not be limited by the technicalities of the words because it's court's duty to consolidate the basic features of the constitution, and federalism is one of the basic features of the constitution. Then Delhi government showed the reasons for bestowing the elected Delhi government with all the state-like powers it has. And Delhi government pointed out that the parliament enacted GNCTD Act and it also added 239 AA and AB to give Delhi citizens more say in their local governance. Then Delhi government argued the phrase in the old act, assist and advise, was expressly repealed and replaced with aid and advice in the new statute. And this replacement points to the clear intention of the parliament to establish a Westminster style government in Delhi, just like how all other states in India have. So in this scheme, Lieutenant Governor merely is a titular head like the governors of other states and not a check post where the Council of Ministers applies for consent for each and every executive decision. So Delhi government further argued, irrespective of the label of the office, in this case it's the Lieutenant Governor, it's not the governor. The Council of Ministers, which derives its support from the elected legislature, shall control the government because the collective responsibility of the council is to the elected legislature. And this legislature further is responsible to the voters. And it requires the Council of Ministers to be empowered sufficiently to make executive decisions and retain the confidence of the legislature. So with this scheme, the Lieutenant Governor has to abide by the decisions of the council. So Lieutenant Governor's role in Delhi should be confined to more like that of a governor and less like that of an administrator of other union territories. Delhi government then continued, the power of the Lieutenant Governor to review decisions is not intended to check the correctness, or to check the merits of such decisions, but it's only to check whether the decision taken by the Council of Ministers is out of the domain, is out of the scope of Delhi government. And if it is actually out of the scope of Delhi government, then the Lieutenant Governor would have the option to refer these orders to the president, and also if they adversely affect the capital of India or if they encroach on center's prerogatives, he would still get the chance to block it and send it to president for his consideration. Then Delhi government pointed out that it's true that clause 4 in 239 AA allows lieutenant governor to use his discretion whenever such discretionary powers are conferred on him by the president, and that lieutenant governor is also empowered to refer any matter which he thinks fit to the president. But these powers shall only be exercised in suitable circumstances, and the lieutenant governor cannot block all executive decisions left, right, and center in a robotic manner, because all these constant references to the president would go against the concept of federalism, which is a basic structure, which is a basic feature of the constitution. So, lieutenant governor has no discretion to check the merits of a decision taken by the council, because it is a prerogative of the council. It is a policy decision of the council. Next, Delhi government argued Article 239 AA vests with the Parliament overriding legislative powers for Delhi in items of list 2 and 3. But the same article also stays consciously silent on the executive powers of these corresponding lists. So this conscious silence on executive powers is Parliament's way of expressing that only legislative powers can be overridden by the Parliament, but not the parallel executive powers. And by contrast, Clause 3 in Article 239 AA provides legislative powers to Delhi Assembly, and Clause 4 provides executive powers to a Council of Ministers elected by the Delhi Assembly. So this express vesting of authority in Delhi Assembly to the Delhi's Council of Ministers is the proper and Delhi government is the proper legal executive head of the Delhi. Then Delhi government continued, Article 73 grants the executive power of the center on issues that it can legislate, and this is also a very general provision of the constitution. Then 239 AA hints that Delhi government is the repository of executive powers as argued before. Now, a harmonious construction of these two provisions, 73 and 239 AA, or after considering that federalism is a basic feature of a constitution, the only possible conclusion, the only possible harmonious construction would be that Delhi government has the executive power over Delhi Assembly, over entire Delhi. So, Delhi government, in conclusion, has the executive powers on entries in list 2 and 3. This was a strong argument by the Delhi government. Then Delhi government also argued having concurrent legislative powers is acceptable, but concurrent executive powers would prove a disaster because there won't be any proper accountability with overlapping chain of command. So the executive power can never be concurrent. So for entries in lists 2 and 3, the executive power rests with Delhi government. So Delhi government argued the effect of Article 239 AA subclause 3 is that all matters on which Delhi Legislative Assembly has the power to legislate are effectively equivalent to the to matters of the concurrent list, but the executive powers on all lists 2 and 3 are reserved with the Delhi government. Then Delhi government finally argued Article 239 AB empowers the president to declare any emergency or suspend a few powers of Delhi government to take over the administration. So 239 AB would become redundant if we accept that the center has overriding authority over executive actions or decisions of Delhi government, because in such a situation, no event would even arise for the president to declare emergency to take over the administration of Delhi, because it's already under center's control. So this clearly shows that elected Delhi government controls the executive of Delhi. Then the 1991 Act as well as rules themselves cannot be used to interpret a constitutional provisions, in as much as they only reflect the scheme of the governance. And here ended Delhi government's arguments. Then it was center's turn to argue, and the center was represented by the additional Solicitor General. And he argued that there is neither any ambiguity nor any absurdity arising from the plain or literal interpretation of provisions of 239AA. So the court shall employ strict interpretation while interpreting any relevant provisions. And he started off by arguing that the phrase any matter in clause 4 means just that, any matter. Center then argued the parliament used the wide phrase any matter to emphasize the superiority of the center in Delhi's governance, and also keeping in view the unique issues that might arise and the immense responsibilities and all the interests center has in Delhi. So the lieutenant governor can review every matter including day-to-day activities so that the center won't get affected by the mismanagement of Delhi's local government. So lieutenant governor is in conclusion entitled to refer any matter he thinks merits the president's consideration, and there is no limitation to this power. Then Article 239 is an integral part of the constitutional scheme, and it is also applicable to all the other union territories in India, including Delhi. Center argued Delhi is no different from Pondicherry because both the union territories are subjected to Article 239 and both of them have a few state like elements, but at their core, they're still union territories, and merely because they have a legislative assembly, they're not exempt from operation of 239, Article 239, which of course governs all the union territories. Then Delhi was retained as a union territory with a few state-like powers, as has been said in the Balkrishna report. So Delhi is still a union territory, and just like all other union territories, its executive powers too rest with the president, and they are exercised through a delegate. And in this case, such a delegate is the lieutenant governor. Center argued the scheme of Pondicherry and Delhi is the same insofar as the chain of command is concerned, that is, union government has the ultimate say. Center then argued that there have been plenty precedents delineating powers of state and center, especially with respect to states and union territories. And merely because Delhi Assembly is a creature of the constitution, the court can't view Delhi in a new light and spare Delhi of existing principles laid down by this court on the subject. So, the well-established principle that executive powers are coterminous with legislative powers is only with respect to states, because a conflict might occur only between a state and the center because of a possibility of different governments, and not with a union territory because after all a union territory is run by the center. Then the center contended that clause 3 of article 239 doesn't empower Delhi to legislate on all entries in lists 2 and 3, but only those entries that are applicable to a union territory, that too if they're in lists 2 and 3. So it's evident that in its essence, Delhi is still a union territory. And under Article 246 subclause 4, Parliament has the overriding powers to make laws on all entries in all three lists and for all the union territories, which of course includes Delhi. And this is further reiterated in clause 3, which goes on to reiterate centre's absolute control over Delhi. Next, Center argued that since the executive power of the union is vested in the President of India under Article 53, the executive power extends to all subject matters on which Parliament has power to make laws. So in a union territory, the executive power of the union extends to any matter in all three lists because it is a union territory. So the executive power in the union territory remains with the President under Article 239. Center continued, the Parliament has anticipated, owing to Delhi's responsibilities in relation to almost every subject, it may become necessary for the center to take any decision with regard to any matter in relation to administration of Delhi, and such a need may also arise in relation to day-to-day function of Delhi. So, Lieutenant Governor is empowered to interfere with day-to-day governing functions of Delhi and also all the government orders. Center further argued that governance in union territories is still unitary in nature, So they are directly under the control of the union cabinet, who is further responsible for the administration to the Parliament of India. So the union cabinet must have enough administrative powers to retain the confidence of the Parliament for administration of these union territories. Then, on the issue of redundancy of Article 239AB, the center pointed out the differences between 356 and 239AB and countered that under 356, the president can declare emergency and assume the control of a state, any state. Whereas under 239AB, president can suspend the operation of any provisions of Article 239AA. And Article 239AA didn't use the phrase assume powers like 356 because the powers already vest in the president. And this article categorically empowers the president to suspend Delhi Legislative Assembly at will. Next, the expression executive action of the Lieutenant Governor and not the executive action of NCT of Delhi was used by the Parliament in the GNCTD Act. And this only goes on to show that executive powers vest with the Lieutenant Governor, and if the Lieutenant Governor differs with the opinion tendered by the Council, Lieutenant Governors always free to refer that decision to the President. And this scheme makes Council of Ministers of Delhi inferior to Lieutenant Governor because Council of Ministers has no final authority. This primacy was again superimposed through Clause 4, which gave the Parliament overriding legislative power. The centre appraised the court that there were many instances where the Lieutenant Governor was not even informed of the decisions, thereby violating the transaction of business rules, and very few instances where Lieutenant Governor exercised his power to make reference to the President to demonstrate Lieutenant Governor's respect to federal principles. Finally, centre argued vesting the exclusive executive and legislative powers to Delhi would elevate Delhi to a state, and the idea of elevating Delhi to a state was tossed around by the Parliament and expressly rejected. And then the Parliament ordained a special status to Delhi, and granting any exclusive powers to Delhi would negate parliamentary and constitutional mandate. The Supreme Court then delivered its judgment, and it was initially criticized for being redundantly lengthy, and the judgment was delivered thus. For a union territory to ascend to the status of a state, it should generally be sovereign within a few domains. But the power of the Lieutenant Governor in Clause 4 to refer any matter to the President and Parliament's overriding legislative powers denied Delhi government the sovereignty. So NCT Delhi isn't just a state in the constitutional scheme and is still subjected to Article 239, so it is still a union territory. But with inserting 239AA, Delhi was elevated to a semi-state while remaining a union territory at its core, while again retaining the legislative supremacy of the Parliament. The Supreme Court expounded that Delhi has a legislature and government elected by its citizens, which can pass laws and control the executive on issues in lists 2 and 3, of course, insofar as they apply to union territories. At the same time, Delhi also has a Lieutenant Governor who reports to the President, who further acts on the advice of the Union Cabinet. So, on legislative powers, Delhi is subservient to the centre because Parliament has overriding powers on legislation. But on the issues of executive power, the Supreme Court said Delhi government does have wide powers, and the court adopted quote-unquote purposive interpretation and concluded that the intent of Parliament in according the semi-state status to Delhi was to enable Delhi citizens to have a greater say in their local governance because MLAs are elected by voters and the Council of Ministers are responsible to the MLAs, member of legislative assemblies. This scheme maintains accountability, and to be accountable, Council of Ministers must have enough power to control over the administration of Delhi. And also, since Clause 3 evidently reserves Parliament's legislative powers, executive powers are deemed to be intentionally not reserved. And the idea of center having executive powers on subjects that can be legislated by Delhi goes against the quote unquote pragmatic federalism. So, just like all other states, the Council of Ministers of Delhi has executive powers over lists 2 and 3, even if Parliament legislates from those lists. But its executive power is limited by Parliament's legislation. So, the phrase aid and advice has the exact import of how it's used while referring to a governor of the state. And consequently, it follows that the phrase any matter has implied limitations, and the lieutenant governor cannot mechanically refer all matters to the president. And lieutenant governor's discretion must be guided by constitutional morality and collaborative federalism, or else it's the voters that feel defrauded. Then Supreme Court held the reason for appraising Delhi on all decisions is to keep him on the loop and enabling Lieutenant Governor to maintain synergy and to give him an opportunity to refer any matter to the president if he feels that such a decision would adversely affect Delhi. Because remember, Delhi is a capital. It is more important to the center and India as a whole rather than just citizens of Delhi. So essentially, the Supreme Court held that Delhi government is the head of the executive and it doesn't require assent of Lieutenant Governor on all decisions. But if Lieutenant Governor actually thinks, after following constitutional principles, that the decisions of the Delhi government would affect the functioning of Delhi, he can refer them to the president and Union Cabinet's call would be final. But this reference to the president shall not happen mechanically, and the lieutenant governor must always be guided by constitutional and federal principles. And because of this, the definition of a state and a union territory in General Clauses Act shall be construed in the context, because for land, public order, and police, union cabinet, central government is the appropriate government, and for all others, it's the Delhi government. Then the Supreme Court ordered a smaller bench to resolve all the other issues raised by the petitioners and the centre by applying these constitutional principles. Because remember, constitution benches confine themselves to a question of significant constitutional importance. And because this bench was not formed invoking Article 131's original jurisdiction, but through an appeal. And this smaller bench comprised of just 3 judges, and one of the judges was also a member of the 5-judge bench. And it was here again Delhi government and the centre, of course. And in this bench too, very interesting and compelling arguments were made. And Delhi government argued that here, by starting off the arguments, that if one goes by the Constitution Bench judgment, Delhi would have full executive powers to the exclusion of centre. The centre disagreed and argued that the Constitution Bench just stated that Delhi government has coterminous executive powers, but it's not to the exclusion of the centre, because under clause 4 of 239AA, Lieutenant Governor has the power to refer decisions to the President, and the Supreme Court acknowledged this power and upheld this power. Then centre contended that Delhi government's case before the Constitution Bench Constitution Bench was that because Delhi is a state and because it is governed just by 239AA, Delhi is exempt by Article 239, because only union territories are governed through Article 239. The Constitution Bench judgment categorically held that Delhi is not a state but a union territory, and the upshot of such a conclusion is that Delhi has no exclusive executive power. At the same time, centre argued that it was the contention of both the centre and the Delhi government that being a state is a prerequisite to claim exclusive executive powers, and that is the only reason why Delhi government is proclaiming it to be a state. And since the Constitution Bench reaffirmed the status of Delhi as a union territory and not as a state, there's no question of exclusive executive power to Delhi government, and consequently no sovereignty lies with the Delhi government. This was centre's argument. To this, Delhi government accused the centre for trying to re-argue the case, and that the Constitution bench clearly settled this matter by saying that for matters concerning Delhi, the elected Council of Ministers has the exclusive executive power, and the Lieutenant Governor is obliged to abide by such suggestion barring extraordinary events. The three-judge bench endorsed Delhi's argument and declared that Parliament has overriding legislative powers, but the executive powers actually vest with the Delhi government. But on rare cases, Lieutenant Governor has the power to refer any matter to the President, and Delhi's sovereignty stands eroded to that extent. Then the bench went on to hear the issues on merits. Chidambaram, representing the Delhi government, challenged the vires of the 2015 notification that bestowed on the Lieutenant Governor's full powers over subject titled services in list 2. And the services entry has two elements. One is State Public Services and the second one is State Public Service Commission. Now, Chidambaram argued Delhi has no State Public Services Commission (SPSC) because it's not a state, and the role of SPSC is covered by DANIX, which is an acronym for Delhi, Andaman and Nicobar Islands, Lakshadweep, Daman and Diu, and Dadra Nagar Haveli Civil Services Commission, which is quite a mouthful. Which is also a joint service commission for a few union territories, and it is entirely controlled by the centre because there are 4 services in union territories. And with this DANIX, centre just allots a few officers to each union territory, and then the Lieutenant Governor or the administrator of that union territory allots respective roles to these allotted officers. After the allotment, the centre's only power would be to transfer a posted civil servant out of the union territory, and the deputation powers still vest with the Lieutenant Governor or administrator of that region. And the centre has literally no say in deputation. So even in Delhi, centre's role would be confined to merely allotting officers to Delhi. The appointment within Delhi will be done by the Lieutenant Governor, that too on the advice of Delhi government, because by virtue of Article 239 AA, Delhi government is a sovereign decision-making body, and it has its own obligations towards its people, and for that it needs to have its own services independent of centre's influence. So after the allotment, the centre's only power in Delhi would be to transfer a posted civil servant out of Delhi and nothing more. Centre has and Chidambaram argued that centre has no say in local transfers or postings once the officers are allotted, because in states, the governor transfers civil servants on a binding advice of the state cabinet. And in Delhi, Lieutenant Governor too has to abide by the decision of Delhi government, keeping in view the Constitution bench judgment. Then the centre argued that the entry services in list 2 contains SPSC, State Public Service Commissions. Then DANIX is a replacement of SPSC. And had there been a State Public Service Commission in Delhi, Delhi government would be free of central government's control. So just like in other union territories too, it is the Lieutenant Governor who has complete control over the local appointments, and that too by virtue of 2015 notification. On the alternative, centre argued that even by virtue of existence of DANIX, Delhi government's power over services stands extinguished because the field has already been occupied. So consequently, the Lieutenant Governor is not obliged to abide by the decision of the cabinet because they were extinguished. Their right is extinguished and it has become an occupied field. On this issue, the Supreme Court decided in favor of Delhi and held that centre's powers end with allotting civil servants to the states and union territories, and after that, Lieutenant Governor has to make postings on the binding advice of Delhi government. On the Delhi Anti-Corruption Bureau element, the ACB and its power to prosecute central government employees under the Prevention of Corruption Act, which and a central government notification was challenged here. And this notification restricted Delhi's ACB's jurisdiction to just Delhi government employees, and the central government employees were expressly exempted. All of this by invoking Section 2 of CRPC. And this Section 2S of CRPC empowers the state government. The question here was whether Section 2S empowers the state government or the central government in cases of union territories to establish new police stations. And here in dispute was which was the competent government to establish establish police stations under Section 2S. Delhi government gave a brief history of Delhi ACB and noted that in 1986, invoking same Section 2S of CRPC, the then administrator declared ACB as a police station for Delhi for both central and state government employees for certain corruption-related offences. And then in 2015, Centre modified this notification and excluded central government employees under its ambit. Then Delhi government challenged the 2015 notification on 3 grounds. First one is that post 69th Amendment to the Constitution, the appropriate government in Section 2S of CRPC is Delhi government, not the central government, unlike in other union territories. And the second one is the notification created a class of persons, central government employees, and exempted this class of persons from prosecution despite committing the same offences. And this classification violates Article 14. And the final one is, by virtue of this notification, the definition of a public servant is altered through a mere notification in Delhi jurisdiction, where it should have been done through a parliamentary mandate. Hence, this notification shall be quashed. Delhi government then argued that criminal procedure is an entry of list 3 in section is a list 3, and section 2S relates to this entry in list 3, and not the subject of police, which is reserved for the centre. Criminal procedure in list 3 reads criminal procedure, including all matters included in the Code of Criminal Procedure at the commencement of this constitution. Delhi government then argued that from the interpretation of the Constitution Bench judgment, Delhi government and Delhi Assembly has virtually exclusive executive and legislative power respectively for criminal procedure within Delhi because it's in list 3. Next, section 3 subclause 58 of General Clause Act defines the expression state and says it shall also mean a union territory whenever required. And the essence of this fiction in the General Clauses Act is to empower the competent authority to exercise its power and not to be tied by any linguistic technicalities. So for Delhi, the competent government would be Delhi government. And Centre argued that establishment of ACB is covered under the subject of police, which is reserved for the Centre. Then Centre argued police in Delhi are regulated by Delhi Police Act, and in the scheme of the Act, administrator or Lieutenant Governor was the head of police. And this clearly goes on to show that the subject is under Centre's control. Reliance too concurred with the Centre on this issue because Reliance was one of the parties. The Supreme Court decreed in favor of Delhi, in favor of Centre and Reliance, and held that ACB's power is in fact traceable to the subject of police, and this is Centre's prerogative. And similarly, the orders of the executive to refrain ACB from prosecuting central government employees as not an encroachment on Delhi government's rights. Then, since administrator was the head of the police under Delhi Police Act, it would be permissible to limit investigation power of the ACB by the very administrator. And in this case, the administrator is the Lieutenant Governor. Then the third issue was Commission of Inquiry. So just to give you a little background, under Commission of Inquiry Act 1952, governments can form commissions. The central government can form a commission to inquire into any subject in all three lists, lists 1, 2 and 3. But the state government can only inquire into entries in list 2 and 3. 2 and 3 because 2 and 3 are the lists on which the state legislature can legislate. And list 1 empowers center's powers. List 1 includes center's powers, so states can't inquire into items in list 1 unless they secure the permission of the center. The commission can have powers of a civil court, that is, to summon witnesses and take evidences on oath, and examining documents and requiring production of any document. So Delhi government formed a commission under the act without the concurrence of Lieutenant Governor. And this commission was to inquire into the affairs of Delhi District Cricket Authority for corruption. And this inquiry was challenged by the central government. Delhi government argued that the power to appoint a commission of inquiry generally and even under the Commission of Inquiry Act is a power coterminous with the governance, as it is a means of a government informing itself of matters of public importance. So this salutary power cannot be denied to any government, and on top of that, Commission of Inquiry Act merely prescribes a procedure to conduct an inquiry and doesn't manufacture a statutory right. The rights flows from list 3. So Delhi government can form an inquiry commission into subjects Delhi legislature can legislate, notwithstanding the Commission of Inquiry Act, because entry 45 of list 3 allows forming of inquiry commissions. It is a constitutional right of all the states. Delhi government also argued it lacks reason to deprive Delhi government of inquiry powers when it otherwise has the same power to appoint an inquiry under entry 45 of list 3. Centre argued that Commission of Inquiry Act is a parliamentary enactment, so its implementation has to be as per the provisions of the act. But the Supreme Court decreed in favor of Delhi government by asserting that forming inquiry commissions is a constitutional right and not a statutory right, and reaffirmed the powers of Delhi government to appoint its own inquiry commission. And the next issue was Delhi government's power to revise land rates under Indian Stamps Act 1899 and Delhi Rules for Valuation. A notification issued without sending a copy to Lieutenant Governor on revising the land rates was under challenge. It was challenged on 2 grounds. 1, for not placing it before the Lieutenant Governor, and 2, for land being a reserved subject. Delhi government has no jurisdiction to revise circle rates. Centre argued that fixing of a circle rate is relatable to entry 18 of list 2, that is land, and even if it is empowered to, it's still void for not placing it before the Lieutenant Governor. And Delhi government rebutted by arguing that stamp duty is imposed on an instrument with regard to the title of the land and not on the land itself. So a stamp duty would be levied on a transfer instrument but not on a land. And the occasion for levy of stamp duty is on transfer of land and the execution of conveyance deed. So Delhi government's power relates to entry 63 of list 2, which reads rates of stamp duty in respect of documents other than those specified in provisions of list 1. And then Delhi government pointed out that it's a common power for states to revise circle rates and cited numerous examples of other states. And the Supreme Court traced the notification to entry 63 of list 2 and upheld the notification in favor of the Delhi government. And then on the issue of special prosecutors too, Delhi government was declared the competent authority because it's a service of the state government. And on the issue of electricity board, the Supreme Court again went ahead with Delhi. So, in effect, it's a win for Delhi government because the Supreme Court affirmed the sovereignty of Delhi and virtually made Delhi a state. And it still left room for centre to interfere, but added enough safeguards while exercising such power to preserve the federal principle, which is also a basic feature of our constitution. Then in 2021, last year, there was an amendment to the GNCTD Act with a voice vote, interestingly. GNCTD Act, to put in a rudimentary manner, is Delhi's own little constitution, and it contains provisions for governance, administration, and procedures with the basic functioning of the government. And this recent amendment made the government of Delhi as the Lieutenant Governor. Like, they literally they're literally taking all the actions under the name of the lieutenant governor, just like how UK in the past referred to, and it still does now too, refer the government as the crown and take all the decisions in the name of the crown. Then the amendment also mandated the elected government to take opinion of the lieutenant governor before taking any executive action, and prohibited the rules of business of Delhi Assembly from being repugnant to Lok Sabha rules. So, in other democratic countries, capitals are given similar treatment. Their local residents have no significant franchise powers because it is a capital and it's too important to let it administered by a locally elected government. Washington has its elected body, but all of its legislation requires a sanction from the Senate. And in London, there are four government institutions sovereign in their own right. So it's even more complex than Delhi. And Canberra of Australia too is not autonomous at all. But on the other hand, Canada's capital Ottawa is significantly autonomous. So all of this goes on to goes on to show that there's no right way of administering a capital, and it's unique to its country's needs. And I believe the structure of Delhi is very reasonable, and also that capitals shall not be swayed by the influences of local politics, just like how Nehru said. And Delhi is being administered with the right agencies, and power has been distributed reasonably, but it's the people that control these agencies that pose threat to the federal principles that the constitution so happily cherishes. So this has been episode 4 of Hamlet to Flaw, and this is the end of the episode. Yeah, I'll see you on the next one. I mean, maybe you will listen to me on the next one.